background. Allow me to proceed to give you just a short overview of the article we are about to begin discussing. So the article is titled Criticizing Judges, A Lawyer's Professional Responsibility by Professor Lonnie T. Brown. So Professor Lonnie T. Brown begin by talking about hierarchical paradigm, whereby he says that the relationship between a lawyer and a judge is typically hierarchical, whereby the judge is a bit above and the lawyer is below, and the lawyer is supposed to respect the judge, to respect the judgments given by judges and all sort of things. However, the judge has also an obligation, and the obligation is to remain neutral and impartial. So in the circumstances whereby biasness is perceived or compromised neutrality is perceived, now the judge is required to recuse themselves or to withdraw themselves. Now, a problem comes in whereby the judge refuses to recuse themselves and there is a lack of appellate review. So in such a situation, the lawyer remains in a dilemma. And now that brings us to the next level of the professional responsibility of a lawyer, whereby as a lawyer, lawyers are discouraged from publicly criticizing judges, but in some circumstances, they are required to criticize where necessary. However, they should balance between the freedom of speech and professional conduct in such a way that in freedom of speech, they are trying to protect the best interests of their clients, and in professional conduct, they are trying to maintain faith in the judiciary. So I hope you're as excited as I am to discuss this interesting article. Now, with that, I'll now proceed to give the questions that will lead to the discussion from our first lead discussant, that is Mr. Dudley. So basically, Mr. Dudley is going to talk about 4 questions, which are basically from the article in 15 minutes maximum. So, Mr. Dudley, the first question you're going to address in giving us your views with regards to the article is, why is it our duty to criticize judges? So why is it our duty, we as lawyers, to criticize judges? Mr. Lonnie, Professor Lonnie, in his article says that lawyers are in the best position and are the best people to criticize judges. So we are asking ourselves, why? The second question, which will inform your discussion, is, what are the available methods for lawyers to objectively and professionally criticize judges? And that brings me to laying a context of this question using the Ahmed Nasir case, whereby Ahmed Nasir basically criticized judges, not only in the Supreme Court, but also judges in Kenya, by saying that they are corrupt, they are incompetent, and they are outright, some of them take bribes. He even says in Twitter that judges in the Supreme Court does not follow the rule of law. They follow the juris pesa, yani pesa money. They follow the juris pesa. So now we are asking ourselves, now because of that criticism, which he did through the social media posts, through media interviews, and even write-ups, he was held accountable and even barred from appearing to the Supreme Court. So we are asking ourselves today as upcoming lawyers, what are the available methods we can professionally and objectively criticize lawyers? And the third question will be, which of these methods, now of the available methods, which one of them can be considered the most appropriate and professional? And then lastly, Mr. Dudley, your question will be whether rules of professional ethics which restrict lawyers' conduct that impugn the reputation of the administration of justice are considered law for the purpose of lawyers' freedom of expression in criticizing judges and also criticizing courts. So, Mr. Dudley, allow me to pass the baton to you. You have only 15 minutes.
Thank you so much, Jabet, for the introduction and for the roadmap which you've given to us. I'll go to your first question, which is, why must lawyers criticize judges? And related to that, why are lawyers the best to criticize judges? You know, they often say, set a thief to catch a thief. Both lawyers and judges belong to the legal profession. Judges are, first of all, lawyers. So lawyers know when a judge has gone astray because lawyers are learned in the law. So from a point of common sense, it's lawyers who can best criticize judges because it's lawyers who know when a judge is or is not following a procedure. It's a lawyer who will know if a judge is or is not applying the law. Secondly, lawyers owe their clients certain duties, the duty to diligently, zealously, competently, fearlessly ensure the law is being followed, or to advocate their clients' cases diligently, zealously, competently, and fearlessly. Fearlessly means without any regard to unpleasant consequences to themselves. Unpleasant consequences sometimes follow even normal advocacy. I think your teacher maybe has told about some unpleasant consequences that came to him when he merely applied for a judge to recuse themselves. And so lawyers also have certain public duties. If you look at Section 4 of the Law Society of Kenya Act, lawyers must ensure constitutionalism, they must ensure administration of justice, they must ensure the rule of law. And so they have that duty. And then we come to the issue of judicial. We come to the issue of judicial independence. And yes, judges are independent. No one can tell a judge how to rule in a case. They must be free without outside pressure or control or direction to decide matters in accordance with the law and the facts before them. But at the same time, we have the flip side of judicial independence, which is judicial accountability. Judicial accountability counterbalances independence so that, you know, the judiciary does not go too far from the rule of law. Otherwise, judicial independence would be an end to itself if there is no accountability. So accountability makes independence meaningful. It means it ensures that judges are staying within the law. And so what are the available options for lawyers to criticize judges? We have the lawful option and we have the unlawful and unethical option. Let me begin with the lawful option. First of all, lawyers can sit in webinars like this and critique court. They can publish journal articles or publish in the platform or other blogs. When the Court of Appeal decided the case of Mitubel, and said many things we felt were wrong. We dedicated an entire version of the platform to critiquing the Court of Appeal. The law has now changed. The Supreme Court overturned the Court of Appeal, and so our critique was justified. So I'm saying that writing articles is another avenue that's available for lawyers to lawfully and ethically critique judges. Judges can also be critiqued by reviewing and appealing their decision. You'll find a common language the learned judge add in saying this or that, in appellate pleadings. So appeals and reviews is another mechanism for lawyers to critique judges and to do so ethically and lawfully. Another option that is available and that doesn't seem to have been taken in the case you spoke about is the one of complaining about unethical conduct. One can file a complaint with the Complaint Commission in the case of judges, or perhaps the Chief Justice in the case of magistrates. Another avenue that's available for lawyers to critique judges. Let me come to the unethical. We live in the age of social media. It's a reality, it's there. We are social media users ourselves. We get some clients from it, and clients. Now, lawyers, especially modern lawyers, have the alternative of going on social media and attacking judges. They can use reckless, they can make false claims. That's an alternative available. And unfortunately, some have taken it. And in other jurisdictions, lawyers have been barred for saying half the things that sometimes Kenyan lawyers have said. I think Kenyan courts maybe have been lenient, but in other jurisdictions, lawyers have been barred. About 2 weeks ago, I saw a petition which was first in time. I've never seen a petition like it. Two advocates, I think that is John Jomo and Kiragu Waduta, filed a Rule 5 and 14 petition, Rule 5 and 14 of the Senior Counsel Conferment and Privileges Rules, requesting for a certain senior counsel to be disbarred from the role of senior counsel. Why? They allege that that senior counsel has used social media unprofessionally, published vile attacks against the judiciary. So the second option, which I hold to be unethical and illegal, has consequences. In other jurisdictions, some lawyers are being disbarred for making those kind of allegations. In Kenya, we now have the first ever petition of its kind to disbar a senior counsel. The petition argues, not to prejudice it, that senior counsel must have unquestionable professional conduct. There must be of unquestionable ethics. There must be an example to ordinary counsel like myself. And so they are requesting for that senior counsel to be disbarred. So that second option has those kind of consequences that come with it. In other times, lawyers can be held in contempt of court by the court, because if you look at Section 56 of the Advocates Act, lawyers are first of all officers of the court. So even though they have a duty to their clients to be diligent, to be zealous, to be competent, and to be fearless, they also owe a duty to the court, the duty of courtesy. They must be courteous to the court. Section 56 also answers the question you asked me, whether placing limits on lawyers' ability to freely express themselves about the conduct of judges is lawful. Yes, there is a law, That law is Section 56 of the Advocates Act, lawyers as officers of the court. We also have law by way of precedent or case law. In the Senate case, the Dora case, the Supreme Court held that decisions of courts also form law. So yes, there is a lawful limit to lawyers' freedom of expression under Article 33 of the Constitution. That same article, Article 33, also says that the freedom of expression does not extend to vilifying speech. And the same article protects the reputation of others. So I believe, yes, that placing limits through codes of conduct on the ability of lawyers to critique judges meets the definition of restrictions placed by law. I believe that it would be justified as well because it is for a legitimate purpose. Which legitimate purpose? The purpose of maintaining public confidence in the administration of justice. And I think the case you've mentioned, I'm mentioning it as little as possible because I'm in conduct of that case. I act for certain parties in it, so I can't speak about it as freely. I'll try to censure myself. That rule, the rule that you cannot say whatever you wish, including the false, the reckless, the careless about judicial officers, serves a legitimate purpose. The legitimate purpose is to maintain public confidence in the administration of justice. We depend on public confidence in the administration of justice as lawyers for our livelihood. If clients know that they can have self-help, they can help themselves, they can go after someone who's offended them and assault them, we will not have any clients to represent before the courts. If the public loses confidence in the court system, then lawyers, as officers of the court, have no business being lawyers, and clients will not have trust in the judiciary. So yes, it also ticks for me the second part of does limiting the ability of lawyers to critique judges the way they wish serve a legitimate purpose? And do they have an alternative? Is there a less restrictive alternative? And yes, again, there are less restrictive alternatives. I've mentioned webinars like this one, and there's a really good culture of critiquing Supreme Court decisions on X. The likes of, I think, Joshua Malizo do it regularly. Wilson Gao, for example, if you follow them, you've seen a decision of the Supreme Court comes out and lawyers read it and say, no, we think there are gaps here and there. Our friend, a friend of Kabarak, Gautam Bhatia Omondi, also does it so well. He compares Kenyan decisions to decisions that come out from the Indian judiciary. And his blog has attained an authoritative status. And so there are less restrictive alternatives. Complaints to the JSC. If you believe a judge has been bribed, you make a complaint to the JSC about that, and the JSC removes that judge. That device works so well because we have judges who've been removed previously for unethical conduct. So yes, lawyers have alternatives to use. Let me stop there and wait perhaps to make further interventions at the appropriate opportunity. Thank you so much, Jebet, for giving me the floor. Thank you.
Thank you so much, Mr. Dudley, for such an elaborate answers and for such a wonderful discussion. I'll now move the floor to Mr. Ian Mathenge. Mr. Ian Mathenge, your question is, what are your thoughts on recusal instances where a judge who is the subject of the recusal retains the discretion to decide whether to disqualify themselves or not? Isn't such a system inherently flawed? So basically, Allow me to lay a small context of this question using the 2024 former president case, that is the Rigathi Gachagua, whereby in his impeachment, the three appointed judges, the bench of the three appointed judges, were required to recuse themselves. But they are the same three judges who made the determination on whether to recuse themselves or not. So basically, maybe you can explain to us how that works and how efficient it is, because for me, I think that it is not fair for a judge who is being required to recuse himself, making the determination himself on whether to recuse himself or not. So, Mr. Ian, take the floor.
Good afternoon, everyone. Allow me to, first of all, begin by laying out a few disclaimers, because the topic today is quite topical, but at the same time, it requires us to really trend on a very fine line, because some of these matters appear to be live in court. And to that extent, I will try as much as possible to restrict myself out of the bounds of what is ethically permissible and impermissible, because today we are discussing about ethics, and we cannot be unethical in discussing about ethics. So let me, having said that, let me go straight to your question, and then I will make a short presentation on what I consider as the lawyer's professional or ethical duty as regards to criticism of the judge. Just more of expounding what my learned friend, Mr. Dadri, had eloquently laid out. So, recusal of judges, and those maybe perhaps who might not be aware of this concept of recusal, because we might be having even lay people join. This is where a judge is asked to remove themselves from the case, because the principle or the understanding is that a judge is supposed to be an impartial arbiter. But where there is reasonable belief that a judge, objectively, that a judge will not dispense justice, either they have a pecuniary interest, they have a personal interest in the matter, or in any way, the judge will not be fair, because ordinarily cases are not supposed to be, or judges are not supposed to be subject to the cases. They are almost removed from the proceedings, and theirs is only to conduct. The cases belongs to parties. So let me begin by saying just that recusal generally are quite controversial by the very nature, because there are two competing interests always. Number one is that a judge feels personally attacked most of the time. So on one side, judges tend to take what we might call a personal approach to recusal. And in that, to that extent, the judges feel personally attacked by the very nature of their integrity and ability to make those decisions is put into question. This is more so because a judge is required by law, without even being moved, to make such a determination. So where that such a determination is being made by a party, to some extent, impliedly, it might be taken as if the judge is somehow not impartial, and they're not able to take that judgment on their own. I would categorize that as what I may say it's a negative. It's not the right way to approach this question of recusal, such a weighty question of recusal. And the second issue, perhaps, which brings recusal into sharp focus, is the issue that generally, even when a judge accepts that they should recuse themselves, in some cases it might bring into question the impartiality of the judge, in the sense that ordinarily a judge is supposed to make decisions without any favor or in any way favoring any party. They are supposed to make decisions independently. And by the very nature that they are recusing themselves, sometimes it might show badly on their side that they are unable to separate between their personal and their professional ads. So having said all that, a lot of feelings, a lot of emotions come with this recusal. And what happens, as lightly put, is that a judge occupies a position of power. So you are asking the person who is occupying a position of power that you don't think that they are capable of making an independent decisions, and for them to decide that by the very nature. So, or in some essence, in some form that you do not have confidence in them dispensing justice without any bias. So to that extent, then, I would argue that, to the question that was asked, generally, our law, the way they have been set elsewhere, a judge who is asked to recuse themselves sometime, as we have seen in the article, they would have a bench from outside that decides, especially on the apex court. That kind of arrangement can be done. But in a case, perhaps like where the apex court is involved, this is the court of last resort, and the court goes on to recuse itself, that then places even a heavier weight on the judges, because recusal of judges is not the only principle that is controlling the entire situation. The judges must be able to balance between their recusal, which is underpinning the principle of fairness in administration of justice, and another form of fairness, which is the right to be heard of parties. So both of them must be balanced. And I must argue that in our case, we seem to be to have given the judges a lot of discretion in deciding this case. They can even decide suo motu. They do not have even they don't have even to indicate the reasons. They can just say that for personal reasons. So the form of accountability when it comes to recusal is quite weak, especially when it comes even to Kenya. And I would have wanted maybe we dwell more into the article, what they say about this particular topic. And so when we find ourselves in that scenario, like, for example, the Supreme Court, which is the apex court, recuses itself in entirety, then another point is brought into account, which is the right to be heard of parties, that the consideration is not only whether the Supreme Court can dispense justice, but also there's a principle of necessity that a court will sit even where objectively they ought to recuse themselves, where necessity demands that the court does sit. And to that extent, then I would argue that we have not been able to balance it very well. And my proposal, thinking out aloud, is if it was possible for us to have a balanced way by saying that perhaps if a judge of the Supreme Court, for example, is asked to recuse themselves, in the first instance, it is presented before the judge. But if someone is dissatisfied, we could have an ad hoc bench for the purposes of recusal, owing to the weighty nature of recusal. Because assuming that a judge is 40 years, or some of them, we have quite young judges in the Supreme Court, they recuse themselves from hearing a case from a particular party. It is essentially implicating the right to be heard of those parties, because at the end of the day, that recusal or the judge's or the interest of administration of justice must be balanced between impartiality and the right to be heard. And that balance, most of the time, I think we don't get it very well. So that is my answer. I hope I have been able to answer that question, and looking even at the case of Gachagua, I think that is present less difficulties in my estimation, compared perhaps to a Supreme Court, which recuses itself, because that is the only court And then that then brings us to the topic of the day. I wanted to create that connection, which is what is the lawyer's professional responsibility in criticizing judges. And as slightly pointed out by Dadri, this remains maybe the only option that a lawyer might have in criticizing the judges, in holding the judges accountable. Because if a judge recuses themselves, and it is the apex court perhaps, there's nowhere else you'll go. I know some people have argued about the jurisdiction of the East African Court of Justice, but that remains quite a controversial topic that you cannot place reliance on 100%. So the only option perhaps which remains is a criticism. But then that brings into focus another question, which is a lawyer a loose cannon? And that takes me to my presentation today. And this presentation I want to contextualize from in the article by Lonnie Brown. And Lonnie Brown starts by quoting what we call ABA. The context of this article is that it's written by an American based in Georgia. So it's discussing mostly the regulations in Georgia. But of importance is Rule 82A of the ABA, which has been adopted by all states except maybe Georgia, actually, and the District of Columbia. And that rule provides that a lawyer shall not make a false statement that the lawyer knows to be false or with reckless disregard as to the truth or falsity concerning the qualification or the integrity of a judge. So that rule, in my view, the author goes on to discuss that Georgia has not adopted that rule because it seems to be quite expansive. But the letter of the law, that rule seems to be quite non-problematic. But the way it has been applied is that judges have tried, and the court have tried to curtail the lawyer's speech on relying on what the writer calls the lofty ideals of the sacred nature of the legal profession, that the legal profession is a noble profession. People ought to conduct themselves with dignity and nobility. But on the other side, what has brought a lot of problems with that rule, which I've just stated and seemed to be non-controversial, is the standard that has been applied. Because when you say that a lawyer is not supposed to make a false statement or is not supposed to make a statement with reckless disregard as to the truth or falsity. So the question then becomes, is it an objective or a subjective test? And this makes a very huge difference. It's not just a matter of semantics. The difference is this. If the standard that we're applying is objective, then a reasonable person, a reasonable lawyer in the circumstances, reasonable, quite debatable, but a reasonable lawyer is supposed to assess the fact and ask, would I conclude, looking at the facts, whether this statement is false or I'll be making the criticism in a reckless manner, which disregards the truth or the falsity or disregards the qualification or the integrity of a judge. So that is the objective test. You remove the lawyer. Now it becomes almost an impartial test that anyone can be able to make that judgment. And on the other side, on one side, that tends to restrict the rules, or it tends to restrict the freedom of expression and of speech of lawyers. Because in that case, the lawyer then is supposed to only criticize the judiciary where there is substantial evidence. Because your criticism should not be based on nothing at all. It should be on substantial evidence, and not only evidence that a reasonable lawyer put in the circumstances would be able to make a conclusion, same as yours. that is the first approach. The second approach is the subjective test. The subjective test, on the other hand, it goes into the mind of the lawyer. Did you believe, if you are saying the judge is corrupt, did you believe that that judge is corrupt? Or did you believe that that statement is false? Or did you believe that you would be making the criticism on the basis of a reckless disregard as to the truth or falsity? So to that extent, this one tends to be more expansive, and you don't know what is in the mind of someone. But of course, it can be deciphered from the facts of the case and of the matter that is being discussed. But in essence, it requires you go to the mind of the person. And when you go to the mind of the person, you need to be very charitable. Yeah, because some people might be hot-wired, others might be cold-wired. So there's all manner of people. So it requires also some subjectivity, some what I may call charitable leading of a lawyer's mind. So to that extent, then, the question becomes, in our context here in Kenya, is there a similar obligation? I must first of all begin by admitting that the Kenyan legal profession regulates the lawyers in terms of the conduct very, very leanly. I can assure you, I've been going through these rules of professional conduct here, and I've never seen another country that has less rules to regulate lawyers' conduct. I think most of the people have to hold on to straws. I think it's Section 60 of the Advocates Act, if I'm not wrong, which says that a lawyer should not conduct themselves or should not conduct professional misconduct or something that is inconsistent with an advocate or being an advocate, something like that. Very vague provision becomes the only saving grace. But in terms of proper conduct of regulations of the lawyers, then that is something that I think that we are failing a lot. And I would say that I think we might think that this will serve the profession properly, but to the extent it's going to harm the profession even more. And I shall argue thereafter on the issues of social media and why the profession must think carefully and bring its rules of conduct into 2024, because we are being regulated by 1950s Act and regulations that are so outdated that they cannot address the ethics of a modern day lawyer. So now things like ChatGPT, those kind of things, and issues of plagiarism, what is the legal profession I know this one is outside the discussion, but just to go and illustrate the way our regulation has really lagged behind. And as we even discuss the case that is pending in court, or at least as we learn away from discussing it, sometimes I can only, but also sympathize, even if we might disagree, sympathize with the judges, because the legal profession is so lax in regulating lawyers, no substantive provisions. Enforceability are big problems. Brothers, sisters club, comrades club, right? So at the end of the day, there's no form of accountability. So judges, they are criticized and exposed. They are not supposed to engage in social media. So they feel as if they are left into the corner to come and fill in the gap that has been left by a genius of not wanting more regulation. Because I think in my case is that the regulations have been there. I think at some point there were regulations on regulating social media, and they were vehemently opposed. I mean, people can argue as to the content, but the whole concept of regulating lawyers and the use of social media, I do not think it should be controversial in my view, but it was very controversial. And then we find ourselves in this extra judicious territories that we are in. So, and please tell me if my time is almost up, but so we find ourselves in this extra judicial territories where judges are forced even to use, because the discipline of lawyers is not the role of judges. If you were to ask me, a judge is not supposed to be involved in the discipline of lawyers. They don't have the capacity, the time, or even the resources, unless things that happen within the judicial proceeding. That sometimes they have to refer them to a body that needs to investigate and listen, an independent body that specializes in the discipline of the lawyers. So, but you can just think when the judges now start involving themselves in the discipline of lawyers, they must be put into the wall completely. And sometimes they might make even decisions that are unconstitutional because of that lack of regulation, if we may think about it. So that goes to the point of just relating this to the Kenyan context and how perhaps I see that the lawyers' regulations are quite silent. But having said that, I don't think that lawyers, even if we have paucity of regulation, I do not think that lawyers are unrestricted, or they have a right to either behave dishonestly, they have a right to talk, to criticize judges, to state false issues against judges, and so on. And before I proceed, perhaps it is important to also distinguish between what I may call opinions and statements of fact, because that regulation 8.2, and for clarity, that is not applicable in Kenya, but it's something perhaps we can draw inspiration based on the article that we are reading. So my view is that a lawyer is not supposed to be disciplined for their opinion completely. The lawyer should be free. They can be criticized and so on, but a lawyer is not supposed to be disciplined for their opinion. But where a lawyer states this false statement of facts, like for example, justice so-and-so, or this court is involved in taking this and this bribe, that's not an opinion, it's an issue of fact. Because as you always say, Professor Ngoya, they always say that you are entitled to your own opinion, right? There's a lot of laxity when it comes to opinion and a leeway to express your opinion. I mean, that is the entire foundation of the freedom of speech. But you're not entitled to your own facts, and we must hold you accountable where you state false facts. So I think that is also a distinction that in this discussion we must bear in mind as a fundamental issue to consider. So lastly, before I hand over, and I will have a few things to say more, but I hope we'll have more time to talk about them, is that this article, if you were to ask me, it makes fundamental points. And one of the most fundamental points that it makes is the counter duty of a lawyer to, because the premise of the article is that a lawyer should be free to make criticism, because that is maybe perhaps the only way of holding judges accountable. And sometimes it is even ethical for the lawyer. It's demanded. Lawyer has a professional duty to criticize judges, because judges are not infallible, and it might be the only way to hold judges accountable, as it was argued by Ochieng. But at the same time, the lawyer, where they have stated perhaps maybe opinions that are false, or not false, actually, the opinions that are incorrect, in that case, there's a counter duty of lawyers or other professionals to correct that misconception. So there's a duty of lawyers generally, other lawyers who are not involved, to correct that misconception. I think that's also a point that is being made in this particular article, and we can draw some inspiration from it. So with those very many remarks, I want to pause at that, and then we can discuss a little bit more. I would like to say something also with regards to social media regulation, and why perhaps I think also the judges must come into reality, because the traditional view that was presented earlier at the start of the proceedings, where the judges occupy almost as a sacrosanct position in the society. They are elevated so much. I think the judges must come into terms with the modern reality of demanding more accountability, that judicial office is a public office and it is not immune to criticism. And in fact, criticism should build institutions and not be seen as putting the judiciary against others. Of course, there are other rules. For example, a lawyer should not state false information and that kind of stuff. And a lawyer should not make statements that undermine the administration of justice in general and the confidence in the judiciary. So I'll stop at that, and then we can pick up the discussion later on. Thank you.
Thank you very much, Mr. Ian Mathenge, for such an elaborate and detailed discussion. I'll now pass the baton to the attendees, both online and physically, to ask your questions. We can begin with who's attending physically. Maybe we can take 4 questions plus comments, and then afterwards we will take from the ones attending online. So yeah, feel free to give your comment, ask your question, and you will get your responses. Maybe you can mention the one you're directing the question to, or just ask generally. Yeah.
So good afternoon. My name is Young Green Peter, and I have 3 very brief questions. So the first question goes to Counsel Ochiel Dudley. So Brown argues in the paper that lawyers also have a role of defending judges against unjust attacks. So how do we deal with the issue of the senior-junior argument, where you'll get that an advocate has practiced for very many years, maybe 20 years, and you're just a new advocate into the profession. And when you come out to defend a judge for the unjust criticism that is given by a senior advocate, you're told you are a mere small claims practitioner, small claims courtroom practitioner. Then the second question, just on the paper, you know very well, most of all the states in the United States of America, with an exemption of 2, do deal with some aspect of a majoritarian judiciary. And in Kenya, our judiciary is mostly counter-majoritarian. What I mean basically is they elect their judges and we do not elect our judges. So does this create a difference on how we are supposed to approach criticisms of judges, that is in USA and in Kenya? Then the last question, what will happen, how will you solve this quagmire where you have a lawyer who has substantial evidence against a judge, but now instead of using the lawful means of criticizing the judges, they go via the unlawful means? So can we get a way of holding the judge accountable because the substantial evidence is available, and also get a way of punishing this lawyer? Or rather, what do you think about the same? I'll prefer the third question to be answered by the second panelist. Thank you.
Perhaps you can stand as you ask your question.
Okay, thank you. My name is Netia Wabomba, and my question will go to either. We all know the Constitution bestows upon clients or citizens the right to an advocate of choice. in the process of disciplining judges, advocates, how do you strike a balance between disciplining a judge and ensuring the client's right to an advocate of choice? Number two, should junior officers or junior advocates in a firm be held responsible for actions of their seniors? Thank you.
Good afternoon. My name is Naomi. My question will be based on the foundation of the whole argument. On what basis are you arguing out that a lawyer's duty is to criticize judges, or rather, what forms your opinion on lawyers criticizing judges and it being a professional duty? Because the past cases, or rather, I could use the example of lawyers being held in contempt for the sole reason of criticizing judges, or rather putting in oral applications for recusal. So how will the lawyers claim their duty of criticism, or is it just an opinion of the bar when it comes to the relations between bench and bar that we are supposed to criticize judges? What's the foundation of this particular discussion? Where do you get, what informs your opinion on lawyers criticizing judges? Thank you.
We can have the final one.
Okay, my name is Soita Shitanda, and my question is on the manner in which we should criticize the judges. We do agree that it is important that lawyers should criticize the judges, but how should we do it? We have seen the president of the Uganda Law Society criticizing the Chief Justice and the Chief Justice of Uganda, and in his speech, he talked about radicalism and extremism, whereby he talks about criticizing them radically by going to the heart of the matter and not the extreme way by just showing that we can argue. And yet we see that some lawyers, especially we see some senior lawyers calling the Chief Justice calamitious, clumsy, and clueless in social media spaces. So should this be the manner in which we should criticize the judges? And my question is, what is the correct way and we should go about such issues? Thank you.
Soita, who have you directed your question to?
To anyone.
Okay, so we can have now the discussants answer the questions. Perhaps we can have one answer, one question, then the other, just like that, so that, we can have the first one. Mr. Mathenge can go first. After responding, we can have Mr. Dudley, and then we can come back to Mr. Mathenge, and then finally come back to Mr. Dudley. So Mr. Mathenge, take the floor.
Okay, let me begin by answering the question about the lawful means of criticizing judges. I think when we're approaching this particular question, we should be a little bit more liberal and aware of the current times that we are living in. The answer to this question would have been very easy, that the lawful means of criticizing judges is writing journal articles. where you are providing reasons as to why you disagree with their judgment or their conduct. Or even a magazine, a printout that is subject to some moderation by the editors and so on, just to ensure that there's a balance between maintaining the administration of justice, and on the other side, there's a balance between the putting across the point that the lawyer wants to put across. But I would disagree with such a mode that is the only lawful means. I would say that the means, in my view, should be viewed quite liberally, including even Twitter, including Facebook, including any other social media means, but provided those means are founded on the lawyer's ethical duties to be respectful and to ensure that they do not state anything that is false against a judge, and do not undermine the administration of justice, provided those particular caveats are put into place. I do not think that there should be any distinction as to the lawful and unlawful means. If anything, in the current modern day, I doubt whether there are many people who read, for example, journal articles, or the impact of a journal article might even be lesser than that of a tweet, right? If its impact perhaps that we want, it might be lesser. Perhaps it might be less credible, but it might be less impactful to communicate by way of journal articles and so on. So just taking into account the realities of the modern day, I think that question should be handled more liberally. Into a chill.
We can now have Dudley answer a question.
Sorry, I'd lost my connection for a moment there. Am I still audible?
Yes, you are.
Thank you so much. Let me go to the question by my brother, Mr. Mudei. I think that the ethical obligations that lawyers owe are vertical, they're horizontal, they're diagonal. The obligations to the public, to the court, to other lawyers, and then a lawyer owes himself as well some duties. Today I've seen some unfortunate video of a lawyer in court who did not take his duty to himself seriously. So this young-old debate, it's also bound by the same set of ethical obligations. Courtesy. I began by mentioning, for example, that judges are first of all lawyers. So you owe them the duty that you owe other professional colleagues, the duty of courtesy, of dealing fairly one to another, one professional to another. And it applies this to the same relationship between older and younger advocates. In fact, older advocates owe the younger advocates more duties because the older advocates are experienced, they're competent, and they have an obligation to train up the younger advocates. The duty, for example, to take in younger advocates for pupillage, to mentor them in the ways of the profession. So I think with the same duty of courtesy that advocates owe to the court and that the court owes to advocates extends to the relationship between younger and older advocates. Because of the disclaimer that I had given before, that some of these issues are live and that I appear for some parties in some of them, I may not be free to comment on all the issues that are raised. I will identify the ones that I can comment on, and then I will. Allow me to go to this so that I use the bit of the time that I've left over from avoiding some of the issues to respond to it. My friend, Mr. Sam Gure, asks whether in view of these general principles that I've mentioned, whether they amount to law, these general principles. Yes, Section 56 is a law, and it says that advocates are officers of the court. Section 56 is expanded through the standards of practice and professional and ethical conduct, SOPEC. And if you look at SOPEC, it says that the general principles that govern lawyers and respect, courtesy one to another, the use of social media, it's there in SOPEC 10. Lawyers must not use social media in ways that bring the legal profession into disrepute. So I think there's very clear legal principles. The case of Rondell versus Worsley, we argued here that case law is also law. If the court has said something, because we run the system of precedent, and Article 10 talks about the rule of law. So precedent forms law. We have court decisions clarifying what is acceptable, what is unacceptable. So I would argue that yes, there is law that limits what lawyers can say and that regulates what they cannot say. That law serves a legitimate purpose of maintaining public confidence in the legal profession. Thank you so much.
Thank you, Mr. Dudley. We can come back to Mr. Mathenge to answer another question.
Let me go to the second question. And first of all, let me go to the last one. I think it was a very good question. And the question was, what is the basis for us arguing that a lawyer has a duty to defend judges, and for us to argue that a lawyer has ethical duties? I would argue that there are three bases for that argument. Number one is that comparatively, as we are looking at, Daddy was arguing, common law cases have, some jurisdictions have tended to deal with this issue even more, confront it in more directly and persistent. Like, for example, India, the Indian Supreme Court at some point, I know it had barred an advocate from appearing before it for some time. So they have dealt with these issues. So to that extent, some of these principles that are applied and the role of the lawyer generally in the common law jurisdiction are expounded elsewhere, and the contours of those particular duties, what they mean, I would say have been well stated. And then the second is just generally the role that a lawyer occupies, and what we call the lofty ideals of the profession, to remain respectful and so on. I think that also provides a basis for this particular argument. And lastly, and for this one, I would say perhaps we need to be a little bit more careful, because that duty to collect, to some extent, in the American context, it tends to come out quite clearly because of their First Amendment and what they call or their view of speech generally as a market of ideas. So where false and truth speech, they are all competing in this marketplace of ideas, and the true speech will come and overshadow, because people are reasonable people. Of course, it's made with a lot of assumptions. The first assumption being that people are reasonable and they're able to access information, asymmetry of information and means. There's a lot of assumption in that kind of thinking, because at the end of the day, you'd ask, is there, is it, can we call it a market of idea whereby, for example, one lawyer has 2 million follow us, let's say on Facebook or other social media, and yourself with your duty to defend just judges and bring out the truth, you have 100 followers. I mean, that might not be quite be said to be a fair market, if at all it's a market. So we need to be very careful about that duty to defend judges. But fundamentally, in general, there is that duty to defend judges, and most of it emanate from just general ethical duties of a lawyer. But I reiterate the point that I said earlier, without repeating myself, that we are linearly regulated as lawyers in Kenya, and I think I'll be making the cases to our disadvantage in my closing remarks. Thanks.
Ian Mathenge. I do note that we have one more question which has not yet been answered, and Mr. Dudley has mentioned that he's not in a position to answer that for now. So, Mr. Mathenge, back to you. You can perhaps answer the last question.
Yeah. I would also want also to eye in the side of as Mr. Dadre has indicated, of not saying much about those questions, but saying just generally, there's a lot of competing interests in some of these issues, and they're quite topical. But I don't want to sort of preempt the processes that are ongoing in judicial forums.
All right, thank you so much. So right now we can take 2 more questions from those who are joining us online, because we only have 20 minutes remaining for the interactive session. Ruth will read out the questions.
Thank you so much, Monica. I want to believe that I can be heard. So I'm going to read out, allow me to extend it to 4 questions. But yes, so we have questions from an anonymous attendee asking what recourse does on filing complaints against judges before the Judicial Service Commission, what recourse does an aggrieved party have when there's reason to believe that the members of the Judicial Service Commission may be acting to save the concerned judge? There's also a question by Joe Karaoke, which I believe the panelists have adequately covered with regards to the principles underlying these restrictions or the actions of advocates. I will ask a question by Sylvia Nyaberi, who's an alumnus from Kabarak Law School, and she asks a very interesting question, which is directed to Mr. Dudley. She asks, judges are not hesitant in calling out litigators on their conduct in court or the documents that they file in court. We have seen judgments where judges were less than kind. Now, this same bench is keen on putting a muzzle on those who criticize them. Is this a case of them dishing it out but not being able to take it? And how do we reconcile the same? Another question is directed to both panelists, which, a minute. They ask, how should we address situations where judges, in response to criticism from lawyers, particularly given the lack of sufficient regulation of lawyers in Kenya, react in an excessive manner? What non-excessive tools are available to judges to defend themselves against such unfounded criticism, considering that they are not in a position to publicly comment? Yes. And then we also have a question from Mr. Ngure, which Mr. Ochiel Dudley had already handled, but I believe that the last part has not been handled, because he asks, apart from these regulations that are there to handle or basically limit the freedom of expression of lawyers when exercising this duty to criticize judges, how do we measure the reasonableness And how do we measure the requirement for it to be justifiable in an open and democratic society? As Mr. Dudley had already highlighted, that it is lawful under Article 56. So yes, and lastly, we have a comment from Gloria Kalambamu, who says, why do we promote criticism and when is it justifiable? One, and while litigation must come to an end, does it mean we take it to the public and accuse the judge, magistrate, especially our being adversarial system? And how do criticism advance jurisprudence? And lastly, why not report malpractice or corruption allegations, and aren't these judges presumed innocent until found guilty? Thank you.
Thank you so much, Ruth Jebet. We can have Mr. Dudley go first, yeah, and then we will have Mr. Ian Mathenke.
Thank you so much. Just to follow up on the question by Mwalimu Sam Gore, you know, this kind of speech, the vilifying speech, is not even constitutionally protected. If you look at Article 33(3), it speaks about reputations of others. If you look at Article 33(2), speech that is meant to promote hatred or that is meant to vilify is not protected. So for me, even if you don't even go past that because the Constitution excludes it, but if you needed to justify, if in any case that's not the kind of speech that 33(2) speaks about, then yes, in my view, it still passes the three-part test. It is lawful, there's the Advocates Act, there's case law, there are codes, the SOPEC, for example, it pursues a legitimate objective, and yes, there are less restrictive alternatives. When judicial officers are uncourteous to others, two wrongs don't make a right. I have been the subject of uncourteous remarks unnecessarily by judicial officers, and Mr. Ongoya is my lawyer in that matter. There's a duty that lawyers owe courts, and that's the duty of candor. A Supreme Court decision came out when a matter was pending under consideration. I wrote a letter exercising my duty, performing my duty of candor, to tell the court that, you know, the Supreme Court has recently given a decision on a relevant issue like the one before you. Please reconvene us so that we can address you on this issue if necessary, but here is the Supreme Court decision. I wrote that letter to the Deputy Registrar of the court, and I copied all advocates. When delivering the judgment, the court made very uncourteous remarks against me. I've exercised my right to review. I appointed the lawyer, Mr. Ongoya, to request the court to relook at that. I annexed codes from comparative jurisdictions around the world, saying that if such a thing happens, there's a new case that is binding and relevant, or indeed any other relevant material that you learn of when a decision is pending, then you have a duty to disclose it to the court. So I think two wrongs don't make a right. We still have alternatives. You can appeal, you can ask for review. You don't bite back. I once saw a video of a child biting a dog that had bit it. You don't bite back in that kind of way. You still pursue the ethical and the lawful because you have that continuing obligation to be lawful and ethical. I think there's a gap in the process. What happens if a member of the public complains against a judge and then the member of the public is dissatisfied with that outcome? What happens? Where do they go? Because 168 says that a judge who is aggrieved goes to the Supreme Court. So where does a member of the public go? There are other gaps in that article that maybe will come out at some point in time. I think it would be an interesting year, this one, for some of these issues that we're discussing. There are more that could come up as we watch these processes make their way through the constitutional organs where they are. Yes, it's lawyers who have the capacity because it's them who know what's ethical, what's legal, and it's them who interact with these judges. They are the agents of justice, and they're the ones who have the duty of zealous advocacy. Perhaps I could stop there and give my colleague, Mr. Ian, the opportunity to pick on some of the other questions.
Yeah. Let me begin with a question on the JSC wanting to, what is the recourse when the JSC wants to save a judge? Though this goes outside the scope of our today's discussion, I think the point is that even the JSC itself shouldn't be immune to criticism. And this perhaps highlights the importance of public criticism in holding institutions accountable and ensuring that there's public scrutiny on some of these decisions. So I think that it's something that ought to be thought about. I think, and perhaps the other thing is that as we do also this criticism, it's important also to think on what is within the bounds of what is acceptable or not acceptable. In our today's article that we were considering, as you remember very well, for those who had an opportunity to read it, John Barrow, who was the petitioner in the case of Barrow versus Laffenspensberger, the case in which formed the fulcrum of today's article, was running a number of campaigns like social media adverts on what was going on and what he thought that the judges had done wrong. So I think we need to be more innovative in holding some of these institutions accountable. I think it's also possible to do just use even social media and use even art to critique some of these institutions like JSC, which has proved to be quite ineffective. I think it would be very helpful, for example, even if we are going to have public trial, for example, if you think a particular judge was acquitted wrongly, or there was underdealings, it's possible for even to do televised or even have proceedings against that judge and light a mock decision of what perhaps would be the proper findings, just to expose some of these institutions and ensure that they are more responsible when they are discharging their mandate. So that's what I would say. The other thing is that judges, I would really reconcile on the fact that some judges use very harsh words when they are describing lawyers. I think that's true. We have seen that, especially even looking at the Supreme Court decision during the presidential petition. I think that decision was very long in language, extremely long, undermined the debate of the judiciary for the longest period. And the standing of the court in a very sensitive and politicized matter. I have also been a big critic of the court on that regards, and I think the court should learn, can do better, certainly. It's not supposed to be a court of emotions. It's a court of logic. And such language does not in any way, when it goes chase and that kind of language, does not add in value of the decision. If anything, it takes away and to put focus into side shows. So it's true that the judges have been quite harsh in describing lawyers and so on. But at the same time, as Daddy Lightly said, is that we should not accept too long. And if anything, I think at the end of the day, criticism of judges is something that the judiciary must sink, because I would argue, looking at even the Gen Z movement and what was happening, the current Twitter anger, some of it borders on anger. and for light reasons. There's a focus and increased scrutiny on public holders of office. And you cannot tell me that all other public officers are supposed to be scrutinized except judges. I mean, judges should move away from the high ills that they have been living in, partly instituted by the colonial judiciary, and has been perpetuated for the longest, and come a little bit down to a point of dealing with a citizenry that is more awakened and is demanding more of judges. And to that extent, they should grow some thick skin, I would argue, and address and look at the positive aspect of the criticism, because I don't think there are people who just criticize, even the ones you think that the criticism is unmerited. I think there's always something that is igniting that criticism, and if we choose to look at that, in my view, I think it would add to the discourse. And at the same time, just be mindful on administration of justice, because the Supreme Court was long and we will not stop in saying that, while the decision itself might have, it's arguable, someone might have said it's light, but using such a language in a decision that is charged in a political matter in a polarized country, I think it's quite long and irresponsible of the court. And I would say that without fear or favor. But at the same time, as lawyers, we should be able to adhere to the rules of ethics as we even criticize judges.
Mr. Ian Mathenke and also Mr. Dudley. And I would love us to do the very last round of answering the questions, maybe the remaining 2 questions. And within that 5 minutes each of you can point out something which maybe has arisen from the questions asked. So you have 5 minutes. We can start with Mr. Dudley.
Thank you so much. I think, thank you. I think that for me, what is emerging is this issue, the need for a balance between the two. Critique, yes, criticize, yes, but be fair, be ethical, be truthful. And maybe there's a role for the JSC to play as well, and the Law Society of Kenya. I mean, for the JSC, because it's the JSC which is a guarantor of judicial independence. We charge them with that constitutional obligation. And I'm yet to see them come out, for example, when judges are accused falsely and consistently and persistently for long without complaints being filed at the JSC. The Law Society of Kenya as well, because it's the guardian of professional ethics. Yet to see LSK call out a lawyer, my society, yet to see it call out a lawyer for misuse of social media in this kind of discourse. So maybe as we go forward, I think this is a big year for ethics, because I didn't hear, for example, Ian speak about whether you can discipline a judge who recuses. He spoke about recusal, but he didn't go that far. So I think this is a big year, and this seminar is timely. Let's continue in the discussion, learn from each other, and because there's always room for improvement. Thank you so much.
Welcome, Mr. Ian Mathenke.
Yeah. So for me, I think this is a timely discussion. It's one that ought to have happened many years ago. And I think there are several points that are coming out from the discussions today. And the first big one that I'm hearing is more accountability, what I may summarize as accountability on both sides. On one side, judicial accountability by way of public criticism is something that judges cannot do away with in this modern day. It's not possible. And we will keep on imposing punishments against lawyers, but it's not addressing the issue. It should just be open to that kind of public criticism, because generally judges are not immune at all to public criticism. And I think it's even more important in the context of Kenya, because if you look at the direction of discipline of judges, there's only one option. If you look at the case of Justice Joaquin Ndung'u versus Judicial Service Commission, a judge cannot be admonished. A judge, there's no other punishment that is available by the JSC as regards to the judge. So in essence, the judge is almost immune if you do not reach the threshold of removal. So you don't want to lower the threshold. At the same time, you don't want at all to immunize judges from any criticism. So at the end of the day, public criticism becomes the only way to vent out against judges, because you can't apply for their removal because the threshold has been put its high for good reasons. At the same time, there is no other alternative modes of disciplining judges that would be less severe. So at the end of the day, public criticism becomes part of it, to like a very important route to vent out some of these issues. That's the first point. The second point that I wanted to point out is that the Law Society should at all match the movements and the trends. Right now, the regulation lags quite behind in 1950s, 1970s, and we are in 2025. To that extent, there will always be conflict, like the one we are seeing today, most of it caused by the fact of lack of regulation. Of course, we could be discussing about enforcement, but I think regulation is there even not only for enforcement, but for purposes of even making people aware of what standards are they supposed to be held into account. Like, for example, how should a lawyer interact with a judge? They should be able to know that. Of course, you think that it is common sense, but common sense is not so common. And then there's a need to spell out the contours of what is acceptable and unacceptable. And the other point that is worth noting, or actually, before I go there, let me just say that it is in fact crucial for lawyers to get ahead of judges by way of regulation in terms of the discipline of lawyers who criticize judges and so on. The reason is because the lawyers will maintain control. You don't want the weaponization by judges to a point where they insulate themselves because the discipline is not there. So I think the Law Society should go ahead and regulate so that at the end of the day, it remains within reasonableness and what is acceptable or not acceptable. And the other point I wanted to note is the issue of social media, though we have not discussed it today that much, is that we should bear in mind 4 things that make social media a modern issue that ought to be thought about by regulators and by ethics thinkers and practitioners. And the first is that social media generally, it deals with faceless, sometimes people with face and sometimes people with faceless. There's something we call what they are calling the courage behind the keyboard. So people tend to be even sharpest in their criticism when they are using social media. So hence the need to come in and regulate. And then number 2 is that the audience is real. Within second minute, the information has spread all over. Whether it is true or it's wrong, cost collecting is such an expensive means once the information has already gone out. Some of the lawyers you see, they have followers to as many as 2 million. If they post, judge say so-and-so has taken a bribe, something like that, it has already gone out, and it's almost impossible to collect that notion among the members of the general public. And then number 3 is the unrestricted nature of social media, in the sense that there's no content moderation. Is what others have looked at it in a positive way, to say that this is the era of democratization of social media. That means the people with or without knowledge can be able to comment. So there's no requirement for someone to have any professional qualification in a subject matter before they comment. And more importantly, is just generally the way the social media modern, there's an interconnectedness of social media that generally the information can go as far as possible. It is cheap and so on. Having talked about that, also we must be aware of another phenomenon that is emerging. That is the phenomenon of awakened, or what I may call a responsive citizenry, a proactive citizenry, a citizenry that is requiring or demanding for more accountability. So on the sides of the judges, they should be aware, or administration of justice, that the citizenry nowadays want more and more answers. Why is my case taking 2 years? Why did you rule this way instead of this way when there is precedent and so on? So the information is out and available, and that creates an issue that requires really to be looked at. One more thing that is coming up from our discussion today is that lawyers are not loose cannons, in the sense that they are not operating without obligations. They cannot speak everything. But the fact that you belong to the legal profession, that very nature imposes some obligations to someone. And as lawyers, we must be mindful. And more importantly, because we are speaking to some of very young and upcoming lawyers, I think it's very important for, as you come up also, you bear in mind that there's a nobility of the profession and there are professional ethics rules. And just because a senior person has done something doesn't mean it's slight. Try as much as possible to exercise your judgment that is even available to courtesy to individuals, just generally, the way we interact with each other. We are not supposed to be making false statements against each other. So I don't think it demands anything more than normal courtesy that someone should have, except that now it's in a professional setting. So yeah, I would want to stop there. Yeah, thank you.
Thank you so much, Mr. Dudley and Mr. Ian Mathenke, for such a wonderful discussion and additions. I would love to give you 2 minutes each to give your closing statements. So welcome. We can start with Mr. Dudley.
Thank you so much. I think this is an interesting discussion because we're dealing with live issues. We had to skip so many areas, saying that this is pending before that forum, saying that I am acting for some parties in some of those. I think once maybe petitions are filed or responses have been made, then they become public documents and we can be freer to discuss some of them. You know, at this stage, you do not know which party Ian is acting for, so you don't want to give away your strategy. But still, I think we've had quite a substantive discussion. I've picked up so much myself, things I did not know. And I'm grateful to Kabarak Avid Readers Forum for this opportunity. I hope that if I keep it short like that level, at that level, I would be invited again. There's a saying that he who does not take too long is invited again. Thank you so much, Jibet, for inviting me.
In the same breath, I thank Kabarak University very much for this extended invitation to us to discuss this timely topic. And my part in short, generally would be all that is needed is just a balance on the two sides, and the awareness that there is no one who wins if we accuse people falsely, if we make certain statements that do not take into account public confidence in the administration of justice. But that does not mean at the same time that they should be, the judges should be immune from public scrutiny, or they should not be criticized. But what it means is that the criticism should be fair, it should be factual, and the criticism should at all bear in mind that we belong to members of the profession. We may ask, why place this duty to a lawyer? And is a lawyer not supposed to have a freedom of speech? My argument is that a lawyer occupies a special role in the administration of justice, which brings a lot of privileges. At the same time, there is also duties, and we should be able to live by both of them, the privileges and the duties. And one of those duties is just be ethical when you are criticizing judges, and ensure that you do not actively act in undermining public confidence in the administration of justice. And because at the end of the day, you might win just one war, but you should have that in mind, that you have an overarching obligation to ensure that you do not unnecessarily antagonize the courts and so on. And another thing I wanted to state is that even for the judges, they need to be more cautious when dealing with applications of recusal, and especially at a place like an apex court, because at the end of the day, public criticism is the only way, or at least they put lawyers into the corner to a point when judges, well, there's a feeling that there's been unfairness, and judges should at least avoid to make those kind of decisions which are extra judicial, despite the lack of regulations. And just to reiterate, the last point is that it's time that the LSK, I hope they will pick up this discussion and try to regulate. I know there might be pushbacks from lawyers, but they should always understand that lawyers do not have unfettered rights to criticize judges as they may want, because at the end of the day, the profession will be injured more if we lower standards to an extent of just that lawyers can say, and even senior lawyers can say anything that comes into their mind. So there is a clear and present danger in the administration of justice if false statement or reckless statement are made without any obligations as to ethical duties of the lawyers, because a lawyer should always say the truth. And contrary to so many people who believe that a lawyer is a lawyer is not a liar. They're not supposed to be a liar. There's ethical rules as to that. I'm saying that mostly because I know there are members also, lay people who are logged in, and there's always that misconception. A lawyer is not a liar. A lawyer is supposed to say to say the truth, especially when they are criticizing people. They're supposed to be more mindful of their ethical duties. So let's take ethics seriously. Let's LSK also delve into some of these issues without also giving judges a blanket immunization, but at the same time just expressing themselves on what is allowed and what is not allowed. Because whether we accept it or not, the conflict will continue as long as this area remains unregulated. Thank you.
Thank you so much, Mr. Ochil Dudley and Mr. Ian Mathenge, for agreeing to have such a wonderful conversation with the Kabarak University Avid Readers Forum. Please, let's clap for them. At this moment, I would love to welcome Mr. Elisha Ongoya, who is a senior lecturer here at Kabarak University and also the convener of today's Avid Readers session. So, Mr. Ongoya, welcome.
Thank you. Thank you so much, Program Director, and thank you the entire team at the controls who have made this day even possible. Let me acknowledge also my two former students and now professional colleagues, Ian Madenge, whom we famously call Aristotle on the one hand, and Ochiel Dudley, whose name I thought was pronounced as Doodley for the longest, until I learned later what the correct pronunciation is. And the two have lived true to their billing right from their student days, that they gave hope that the profession was in safe hands, and they continue to tread that. And thank you, Dudley, for teaching me that there's another saying in the book of sayings that if you don't stay too long, you'll get invited again. Whatever it is that you got that from, I do not know, and I can't vouch for its accuracy. But because I believe you generally, I want to believe in the authority of that saying. We at the Avid Readers Forum remain committed to the fact that the core business of the university is to conduce an intellectual environment. And that if we do not do that, then our own relevance may be questioned. And we continue looking around for themes that are in the vogue and looking for readings around those themes to focus our conversation. And that's precisely what we have done with the reading at hand, inviting our two eminent scholars to be able to make that contribution. And Ian, I hope that the waves behind you are an actual water body and not an impression you've created to give us an impression of a water body, because some of us are already admiring that we were where you are in comparison to where Mr. Ochiel Dudley is at Bond. You appear to be sitting in a more relaxed environment than the workspace that Ochiel Dudley and myself find ourselves in. But having said that, we hope to continue doing this, not just now, but we hope that the Avid Readers Forum will definitely outlive all of us and become the focal point for intellectual discourse on this continent, just as we've seen similar discourses happen in established universities like Oxford and Harvard and other places. With your cooperation, Ian, and with your cooperation, Dudley, and like-minded people, we have no doubt in our mind that in our living history, we shall see the Avid Readers Forum grow to such an acclaimed forum for intellectual discourse. I also acknowledge the students of the Kabarak University School of Law who have sat in the plenary at the auditorium, giving the physical presence to this event the touch that it requires. And to our student coordinator, Ruth Jebet, we don't take it for granted that you pulled this through together. When it began, it struck me as too close to call, but I thank God that you have pulled it through. And we look forward to having at least one or two similar occasions before this semester comes to an end. Allow me to stop at that and go back to the control room to our program director to wind up today's session. Thank you so much, and God bless you abundantly.
Let's pray. That is the end. Let's pray. Everlasting Father, Lord of Lords, King of Kings, we bow before your presence. Thank you because of this precious time that you've given to each and every one of us. Thank you because of giving us to learn, O King of Glory, and even the opportunity to engage with legal minds. As we depart from here, oh God, we pray that you're going to guide us, you're going to be there for us till the other time we convene again. Thank you, because you've heard and you're going to do it according to your own will. In thy name, I do pray this, trusting and believing. Amen.